Hello, and welcome to everyone. I would first like to thank the entire Dartmouth Political Union executive team, as well as our great ambassadors for all the work that goes into preparing this and all our other DPU events. For those that have not been to a Dartmouth Political Union event before, we're the premier club on campus devoted to nonpartisan discourse. We aim to bridge the divide between our student body and help them learn from each other as well as from our terrific guests. About our speaker tonight, Professor Sullivan is a leading theorist in criminal law, criminal procedure, trial practices and techniques, legal ethics, and race theory. He is the faculty director of the Harvard Criminal Justice Institute and Harvard Trial Advocacy Workshop. In 2009, he became the first ever African-American appointed master in Harvard's history and served as faculty dean for Winthrop House at Harvard College. In 2007, in the wake of Hurricane Katrina, Professor Sullivan was asked to create a system to resolve a criminal justice crisis. Thousands of citizens were incarcerated in and around New Orleans without any representation and without any official records. And Professor Sullivan stepped up and helped solve that crisis. While Professor Sullivan's resume is quite impressive, we should know that the DPU never endorses any of its speakers or their views. They're entirely their own. The event tonight will consist of prepared remarks by Professor Sullivan and will be followed by a moderator-guided Q&A, and finally we'll end with an audience question and answer period. You can type your questions in the Q&A box below, and they will mostly be chosen based on upvotes. So please make sure you like the questions and you type your questions there. If you would like to ask your question anonymously, that is, if you would like me to ask it for you, please indicate that by clicking the checkbox. You can visit us at thedpu.org, email us at dpu@dartmouth.edu, or go to our Instagram at the DP Union. With that, I would like to extend a very, very warm welcome to Professor Ronald Sullivan.
Thank you very much, Vlado. I appreciate the opportunity to speak, and I appreciate the opportunity to be at Dartmouth, even if virtually. I really wish I could have been there in person, but times are such as they are. But I have a deep and profound respect for your institution and feel honored to be here. I'm going to try to keep my opening remarks relatively brief in order to facilitate time for back and forth, for dialogue, and for Q&A. So first, I want to say a word or two about how I got interested in the issue of wrongful convictions. So I started doing some academic work. I wanted to try to figure out why we have so many wrongful convictions in the United States. So my research assistants and I began to look at every wrongful conviction in the United States and try to figure out what were the similarities. So we did the relevant coding of the data, and it turns out pretty much as we suspected, that the number one cause of wrongful convictions is eyewitness identification. Eyewitness identification. So the thing is, we human beings, we think of our memory as though it were a video camera and you just sort of replay it and you're seeing everything. What we don't realize is that memory is highly contingent on a whole range of things, and things we think we remember aren't always accurate. So in doing this work, we figured out the top 3 or 4 reasons why there are so many wrongful convictions. And then the idea was to go to prosecutors' offices and began to train them to recognize the sorts of cases where we see wrongful convictions so that they won't make the mistakes that they've made and innocent people spend years and years and years in jail. Before I got a chance to write that paper, I got a call from the district attorney in Brooklyn, New York. And I'll just give you the abbreviated story. After some conversation, he invited me down to design a conviction integrity unit and to run that unit, which I did. I commuted back and forth for about a year and a half. I started it and ran it. And in the first year, we found 10 wrongful convictions in New York. Now, I want to tell you a story about one of them just to frame this discussion. So here we go. There was a murder in Brooklyn. Then there was an eyewitness, and the eyewitness says, I was in the vestibule of my tenement apartment building, and I saw the defendant in an argument with this other guy. Defendant pulls out a gun, shoots him in the chest, nearly point blank range, a few inches apart. That person, eventually who would become the decedent, stumbled out of the tenement. He opened the door, stumbled out, down 2 or 3 stairs, and then fell on the ground. Ended up landing on his back just a few feet from the door of the tenement, or from the steps that lead to the door of the tenement. So person was tried, convicted, and 17 years later, I opened that file and took a look at it. So one of the first things I noticed, because it wasn't mentioned in my bio, but I started my career as a public defender in DC. So I've always not been an academic. So I've tried dozens and dozens and dozens of homicide cases and are fairly familiar with that sort of crime. I took one look at the autopsy photos, and what I saw was a man there with a big hole in his chest. And to the lay person, that looks like somebody was shot in the chest. To me, I saw it and was like, oh my God, this man was not shot in the chest. What's going on here? So you see, entry wounds are very small little puncture. The bullet goes through, it explodes, it does sorts of damage. And if it comes out the other side, there's a big gaping hole. So, without having a medical degree, I looked at the picture immediately and said, no, something's wrong. Not shot in the back. Didn't mean that the defendant was innocent, but it meant that the eyewitness was either mistaken or lying about something. So then I kept looking. I looked at pictures of the entryway, the vestibule. And what would you expect if someone is shot point blank in the chest? Right? You probably expect blood to splatter. No blood. No blood there. So I said, well, this is weird. So I sent some investigators out to look at the facility to see if there were bullet holes. Because the complainant said shot about 6 times, 4 bullets had hit the decedent. Looked there, no bullet holes. This is a publicly owned building. I sent someone else to go down and check and see if over the 17 years, the walls had been redone. Didn't look like anything had happened in the last 50 years in that building, quite frankly. But we wanted to check. So I checked that out. No work had been done. I said, where are the bullet holes? Long story short, the person was just lying. The person was lying in order to protect the actual individual who had done the shooting. And when you look at it and say, hey, there's this big hole in the chest, it's easy for someone to say, oh, they was shot in the chest. Police came, they took a look and said whatever and just moved on. The defendant sat in jail for 17 years and 4 months until we brought that case up and asked for the judgment to be vacated in the interest of justice. Subsequent investigation showed us what really happened in the case. But so that's an example of how someone is convicted. Now, over my career, my team and I have done over 6,000 unlawful incarcerations. We've gotten over 6,000 people out of jail who were unlawfully there. And some percentage of those have been convicted. And some of those people have been in jail for 30 years or more. And others, unfortunately, I was able to get a posthumous vacator of the conviction. They had died in prison. And that's the hardest one, when you die in prison for something that you did not do. So that to me is not enough, right? So it's obviously great to get people out who shouldn't be in, but shouldn't we figure out, do a root cause analysis of how in the world we got to a position where people were put in jail for mostly homicide, who demonstrably, by clear and convincing evidence, did not do the crime? Strikes me that that means something is critically wrong with the criminal legal system if we find ourselves in that position. So what do? Root cause analysis to figure out the problem. That takes us square to the prosecutor's office. And I'll say something a little later about the public defenders who had a role in this in terms of not vigorously representing their clients and not figuring some of this stuff out decades earlier. But the prosecutors are the ones who make the charging decision. The prosecutors are the one who makes the recommendation that usually is followed with respect to sentencing and so forth, the most powerful actor in the courtroom. So what's going on in those offices that you see something like this and a case goes on? There was one other case I'll mention and just highlight. We solved that case because at the time that the gentleman was arrested, some 20 years before, he had a receipt in his back pocket showing that he was in Disney World with his family 20 years ago. And that receipt went from police file to prosecutor's file, and it sat there for 20 years without anybody really noticing it. And he sat in jail for 20 years, and he was, 1,000 miles away from Brooklyn when that thing had happened. Can't have that. We've got to figure out what to do. So this took me full circle back to my academic work, right? So we had already figured out what some of the main issues were in terms of wrongful convictions, what commonalities they had. So number one, for example, is eyewitness identification. And if we break that up a little bit, cross-racial eyewitness identification is even worse. Why is it worse? And I'll just pause here in a parenthetical. I partnered with some people at the Harvard Medical School and some folks in the graduate school, some academic psychologists. And here's the notion. It turns out that if we are not exposed to people of particular races between the ages of 0 and 3, we really have a hard time distinguishing them unless we realize it and practice it. And the reason is that we're hardwired to look for certain sort of cues that allow us to distinguish between folks. And the things that we're used to, if we live in a homogeneous environment, are not the things that separate and differentiate different races and ethnicities. So, for example, I grew up in a grossly segregated area. So the first time I was ever in a classroom with a non-Black person was at Harvard Law School. So that'll give you some sense of it here. So my mind was trained to look for things like hair length, not color, not eye color or anything like that. Hair length, height, these sorts of features. Presence, absence of facial hair, these sorts of things, my mind very subconsciously was trained to look at. People where I grew up didn't really have different color eyes, and I didn't realize this, but I didn't look at people's eyes until I got to the Harvard Law School, and someone said, oh, so-and-so with the green eyes. It's like, how would I know what color eyes? I was thinking it's funny now as I look back on it. But, I had no clue, no earthly clue. Wasn't trained to look at it. Hair color, not trained to look at it. So people make honest mistakes cross-racially, if they haven't been exposed to folks of different races and ethnicities. They make honest mistakes because they're just not looking at the things that differentiate that group. And then eyewitness testimony is so powerful. You get in the court and say, yes, that is the person I saw, and point at the defense table and so forth. So huge. Another example is of coerced confession or force-fed facts. If someone says a fact that there's no way that they could have known except someone telling them, exogenous to the interview, right? Then, exogenous to their setting prior to the interview, then that is a cue that someone has biased that individual, and the individual is saying things that in order to please the interviewer. Another one quickly, I don't want to belabor this, juveniles without their parents present. Juveniles without their parents present. Doesn't mean that when it happens, all of them are all of those confessions, the last two had to do with confessions, all of those confessions are not accurate. Some may be, but the rate of error in confessions where a juvenile's parent is not present is huge, because police will say things like, and they're allowed to do this, the Supreme Court has said so, look, if you just tell us, that you did X, Y, and Z, we'll clear it up and we'll let you go home. And not just kids, but even adults, believe it or not, actually believe this. And they say, oh, and then they get to admitting to everything and say, all right, can I go home? And the police are like, no, you can't go home. You just admitted to murder, and they get locked up. But identify beforehand those sorts of cases. Let's take eyewitness identification that are prone to error and have an extra layer of corroboration beyond what the prosecutor's office normally does in order to ensure that you've got the right person and the right circumstances. So if you know going in that a single witness identification case is prone to error, then don't rely only on a single eyewitness identification testimony to make your case, but go out and do the work necessary to ensure. Because if you go and do the work, go beyond what is right in front of you, then chances are that you will find some evidence that will either corroborate what the witness said, or evidence that suggests that, well, this is not exactly, this doesn't exactly work. So in the case I started with, you had the single witness with the gunshot wound. That's not enough. They should have gone to the coroner and said, this is what the person said. Does this match with the biological evidence? When I showed that file to the existing coroner, she said a couple things. No, yes, he was shot in the back. No way he stumbled down the stairs. Why? Because where he was hit, he would have died instantly and collapsed. And moreover, one of the bullets broke his ankle. He was not walking anywhere, not 2 or 3 steps. And third, because of where it hit, 2 liters of blood would have blown out. So it would have been blood everywhere, including on this eyewitness who claimed that she was right there and saw it. A simple step could have saved a fellow human being nearly 20 years of wrongful incarceration. I'll stop there and turn it back over and answer, have a dialogue and answer questions.
So, I mean, that's quite compelling. And I guess I'm curious, some of these issues that you mentioned, maybe can be fixed through having new procedures within the police departments, maybe partly with criminal review units. But some of them are more difficult, like the eyewitness testimony, cross-racial. That would depend on how integrated the communities are, etc. So with those being the problems, what are some of the most effective solutions that you found? And to what degree are they local versus national? And what can be done perhaps at each stage from your research on the topic?
No, that's a great question. Most of criminal justice is local. A lot of people don't realize that the national government can incentivize certain changes in the way that they incentivize speed limits being 65 miles per hour. But, 90 some odd % of the action is in local territories, in states and cities. So, there are some easy fixes that academics know about, that policymakers know about, but we don't have the political will yet to undertake. One example is the way in which we do photo arrays, right? So you've all seen photo arrays on television. You have a picture of this is not of a person, but it's the best I can do. Right. So you hold a picture of a person and then flip to another picture and say, or what you've probably seen on TV is a board of folks. And it's, one row and two rows, either 6 or 8. And they say, point to the person. We know study after study for the last 30 years that is prone to error. Why is it prone to error? 2 reasons. The person picking, when you do it like that, tends to pick the person that she thinks looks most like the assailant. Not the assailant, the one who looks most like the assailant. The second reason is that the person doing the lineup or the photo array gives off nonverbal clues as to who the officer wants the witness to pick. Nonverbal cues. So that's, so some of you may have seen these television shows about the guys who almost seem like they have extrasensory perception and can, I forget the name of these shows now, but, a couple of them were very popular and they came on as consultants to help the police. These people actually exist in real life, and there's a whole literature and a guy at University of Chicago who is an expert at picking up on nonverbal cues, and that's how they can, read people. And those who use that for ill are great grifters because they can really fool people into doing what they do. So one way, for example, with this is the data show that if you show sequential pictures, is it this person, this person, this person, this person, the error rate drops precipitously. And importantly, the rate at which witnesses pick the assailant increases. So you've got it in both directions, going in the direction that is positive for the criminal legal system. If you do that, and if the person doing the pictures doesn't know who the suspect is. So you go to someone else in the office and say, do this. And sometimes the person's not in there and you tell the witness that. So there are techniques that academic psychologists and others have perfected over the years, but we tend not to want to use bunches of them. I don't want to give you time for more questions.
So I have a quick follow-up on that. So we know of techniques that would help.
Yep.
I presume they've been implemented in certain cases and haven't in others. So what have the successful implementations look like? Why do they decide to go forward with that versus why are some departments more stagnant? Is it that this knowledge is not widely available? Perhaps it's not recommended by relevant authorities, as you said, the national can give out some guidelines, or is it some other unwillingness to go forward with?
The latter. It's some form of other unwillingness, and it's hard to get to the bottom of why. But this sequential photo array that I just described. So, for example, New Jersey, for whatever reason, has been doing this for years, and it's worked out well. Some jurisdictions will say, "Well, we just don't have the human resources capacity to find another officer who doesn't know who the suspect is. Very small, we don't have it." Others will say, "Well, it takes too much time." Others will say, "Well, then people won't pick anybody," which we know the data show that that's just absolutely wrong. but this is some of the things we hear from local jurisdiction. It is a deficit of will. I can't say 100% why that is. Perhaps it's just the inertia of having done it a certain way for so many generations that police officers or police departments don't want to move on things like this. But that is the case, sadly.
I'm curious, this sort of goes around the issue of what is the role of the local community within, justice, within seeking justice for crimes. And it seems to me that there are somewhat two sides to that. For example, with the Arbery case, it was the community that was able to get some sort of prosecution and finally conviction. But at the same time, there's probably some risk of persuading the jury through action, through the national will. So I'm curious what your view on that is, and how does one balance, sort of moving and pushing a system that seems to be stagnant in some cases where it definitely shouldn't be, versus allowing, professionals like yourself in the system to go get to justice.
Right. Another great question. So I think, I'm suspicious about ad hoc forms of justice. So we talked about Ahmaud Arbery. I think the jury made the right decision in that case, and I watched it. But you don't want sort of masses of people influencing the prosecutor's office and potentially contaminating juries case by case. I think cases like it's necessary in a case like Ahmaud Arbery to bring to light what some of the systemic problems are in a system, and then use that to make systemic reform. And then in the cases that follow, the system can and should work better. So, but what we don't want is what I don't want, and what I think is potentially dangerous, is a form of mob justice, that when the loudest people in the room start demanding results, that all of our systems bend in that way. The criminal legal system is terribly flawed, and it needs a lot of work. Don't get me wrong here. I just want to caution us that the way to do it, I think the better way to do it is through systemic reform. And sometimes it does take a series of loud voices to sort of pull off the veneer, or rub through the veneer to sort of see what's really going on. And then once we see it, I'm a firm believer that people of goodwill will ask their elected officials to do the right thing. Because who wants someone sitting in jail for 20 years who didn't do it? I don't think there's anybody out there that wants that. And I hope and pray that no prosecutor wakes up in the morning and says, hey, geez, I think I want to go put an innocent in jail for the rest of his life. Right. And if you start from that premise, then I think we can do some work. But we've got to stop pretending that there's nothing wrong with the system, we as a culture. And that's the first step in order to get to the bottom of the flaws.
I am curious, you just mentioned, you touched back upon, the time in prison that these people spend sometimes. And, in the past, you've said that you find that they somehow get over it and live fulfilled lives. But I wonder, in your experience when talking to people who have been wrongfully convicted, is there a part of them that just, forever fears that they will again be set up? Is that something that troubles them for the rest of their lives? And, shifting slightly from the personal to the larger scope, a lot of them, from what I've read, are not really reimbursed in any real sense for what's been done. So do you see area for improvement there? And, perhaps they should be given back their liberties, but also helped get back on track in life?
Yeah, to the first part of your question, the folks that survive these long prison sentences are among the most remarkable men and women I've ever met in my life. And they have a depth of character that surpasses mine. And they have character traits that I can't even imagine. So believe it or not, those who really make it and thrive have come to terms with it and don't sort of dwell on the past in the sense of being fearful of being locked up again for a number of years, and amazingly are not bitter about it. Now, they've been harmed and they've been beat up and they've been gang raped, and those traumas never leave, to be sure. But their sort of faith in humanity generally is at a place that I just can't imagine. What I postulate is that in order to manage the absurdity of their situation in jail, that they've had to come to terms existentially with that absurdity and see the good as opposed to the bad. The second part of your question, you're absolutely right. In some states around the country, there's a limit to which states can be sued. And you have people who spent 10, 20, 30, 40 years in prison, and the state has the audacity to give them $50,000. They have taken away the lives of these men and women, and to pay them a lousy $50,000 to recompense for all those years, I think is plainly immoral. Other states around the country, states do allow themselves to be sued and don't have these limits on damages that others do. And there's no way that the civil legal system can fully recompense those people for all those years. But the only thing we do have is money damages, and it ought to be adequate for the time that they've been away from their families.
I am curious, there's often this lens of what are the systemic things at play that are happening. So, and there's a lot of talk about money and politics. So I'm curious, are there equivalents essentially in the justice system, whether it be, on how courts are influenced, or perhaps the private prison complex, or things that, you are more aware of that you've seen as a pattern that seem to be shifting in this direction of more incarceration, and with that increases in wrongful incarceration? Sort of what are the key players in that picture?
Yeah, it's a mix of legislators and prosecutors' offices and police departments. You guys have probably heard of some of them, and it doesn't take a Harvard professor to figure out certain incentive structures are bad policy. But let's take New Orleans, for example. You mentioned that in the opening. The police department, for example, received a cut of the fees generated when a person was arrested. So when you're arrested, none of you fine Dartmouth students would know about this, but you're arrested. And even if you take a plea and no jail time or anything like that, you still are assessed something called court fees. And these court fees get divvied up in a lot of jurisdictions between the prosecutor's office and the police department. And if court fees make up a significant part of your budget, again, it doesn't take a rocket scientist to see that incentivizes you to do more arrests, more court fees, more money for your department. You will stay gainfully employed. So we've got to remove these monetary incentives from the criminal legal system, because that will do nothing but generate more arrests and more convictions. We have had a meaningful reform across the country with respect to bail. Bail used to be this just multi-million, maybe even billion-dollar industry. But many jurisdictions have now moved to a no bail system, which we think is better, because the bail money and the interest accrued on that money that will flow through the system and fund the courthouse, a little bit to the prosecutor's offices, a little bit here and a little bit there, as adds up. And pardon me, that incents these actors to behave in a way that they may not otherwise behave. So I think we do have to take a good look at where the money is. And usually when you follow the money, you figure out the incentive structures.
This is a slight departure. It's about the nature of evidence and what you think should be considered evidence in trials more broadly. I was reading, in part of preparation for this, that in Supreme Court precedent McCleskey versus Kemp, the court ruled that statistical evidence should not be and cannot be used as an argument for denying someone their constitutional rights. And the ACLU argued very strongly about this. So I was curious what your thoughts were on that. And, again, what are the trade-offs of, accepting types of statistical aggregates as evidence versus not accepting them? And is there really a strong case one way or the other?
Well, McCleskey is a very controversial case for some of the reasons that you described. So the Supreme Court essentially has ruled that courts should individuate with respect to their decisions. That is, look to the litigant in front of it, because that's the only thing that they should be relying on, the evidence with respect to that particular individual. The aggregate data, the court said, is not reliable evidence because it doesn't account for the particular circumstances of the litigant before the court. Advocates on the other side say that it, in fact, is evidence of systemic biases, that it's not a mistake, that and the facts of McCleskey had to do with statisticians showing that if a white person was a victim of a crime, then the perpetrator had, and I forget the number, but an extraordinarily increased chance of getting the death penalty. And the advocates say that says something about the biases that inhere in our system, because there are equally gruesome crimes perpetrated among people of other races and ethnicities. And why is it that those perpetrators are significantly less likely to get the death penalty? And they argue it's because that their lives are not valued to the degree that white lives are valued. So the Supreme Court says, well, even if that's true, doesn't have anything to do with this particular case. The judge should only look at the facts in front of this case. So notwithstanding the jurisprudence here, I think that we have to do extrajudicial work to ensure that all lives are treated equally, and that human life itself is appreciated and cared for and protected. And the courtroom may not be the best venue to do that. So this may be better done by folks outside of the judicial system, so that when people come into the judicial system, then they're not filled with these biases, including judges. And there are judges all around this country who take one of these implicit bias tests, and they're shocked to learn, for example, that they have anti-Black implicit bias. I'm not shocked, because we all are products of, 21st century Western tradition. And there's so much in our subconsciouses that it's hard for us to sort of, if we're not conscious of it, it's hard for us to break out of it. So I think we have to do a lot of work outside of the justice system in order to right that wrong. So,
we have a lot of audience questions, and we will be transitioning to that in a moment. So I will ask you my last question, and that would be basically, a lot of us are sort of laymen when it comes to the law and the judicial system, both, the traditions, as well as in the United States. So are there any books that you would recommend, or, podcasts or other sorts of media that can help one understand, what the roots are, and how that is manifested? And, for example, a lot of people don't know the how self-defense laws work, and that's complicated. And, I'm sure there are a lot more fundamental things that perhaps we can glean into.
Well, if you, particularly for enterprising college students, if you want to learn something about the sort of foundations, the roots of American law, there's a great book. It's called The Canons of American Legal Thought by David Kennedy and William Fisher. A great book that'll give you the foundation of how, through a series of essays about how the law was formed, what it means, how it's animated, what it attempts to do, and I think that's a good starting point. If you want a good self-defense article, since you mentioned self-defense. I wrote one for a lay audience right after the Wisconsin verdict. I'll send it to you. You can, this is not it's free, so I'm not.
Yes.
This is not like a sale or anything.
We will share it with our membership. I know
you can look at it online.
It's on Quillette.
It is, yeah. And it does, I think, a thoroughgoing analysis of the history of self-defense and why I thought that verdict was a correct verdict.
And in fact, if one of our technical support people wants to add that in the chat, that would be great. But with that, we will be transitioning to our audience guided question and answer. And our first question will be from Kavya Nivarthi. Kavya, would you like to ask your question?
Yeah. Hi, Professor Sullivan. Thank you so much for speaking with us today. I followed the Stephen Donziger trial and sort of all the aftermath of that. So I'm wondering if you could comment on that and what the implications are for activism and the influence of corporations in our justice system.
Ooh, big topic. Thank you. Is it Kavya? If I pronounce that correctly.
Yeah, you got it. Thank you.
Great. Wow. So let me just take one piece of that incredibly important topic. Let me just narrow down to the sort of corporate influence in our criminal justice system. Like every other area of our political economy, the corporate influence has a disproportionate impact on the criminal legal system, and you wouldn't necessarily think that that's the case, but as it turns out, corporate interests with respect to what becomes criminal, how it's enforced, and even sentences are well below the surface, but their impact is felt every day. Now, what do I mean by that? So there are organizations and PACs and not-for-profits that are funded by any number of corporate interests that have access to legislators that common persons do not. They use that access to even write bills. So, for example, the Stand Your Ground law that we see, you guys remember Trayvon Martin and George Zimmerman. This was actually written by a group that receives millions and millions of dollars every year from certain corporate interests. The actual law was written and sort of handed to legislators and said, let's pass this. And the sort of implications of it were never really fleshed out but the sort of influence of money and politics works out such that this sort of thing can happen. And so the bottom line is corporate influence in the criminal law is alive and well. It tends to be below the surface and not easily detectable, but it's something that we as citizens should know about. And that's why these transparency laws are so important. Who's getting money from whom, what sort of material is being transferred, et cetera. I could do a whole hour on that. So email me if you want more.
All right, so our next question will be by Rhea Carty. Rhea, would you like to ask your question?
Hi, thank you so much for talking to us today. You talked a lot about what defenders can do to better defend their clients. And I was wondering if instead, should prosecuting attorneys be blamed for aggressively seeking longer and harsher sentences? Or do you think they're just doing their job after being pressured to convict for the sake of their career? And what systemic changes do you think could help fix this?
Yeah, so I actually didn't get around to talking about defenders. I mainly was talking about prosecutor offices. And I think that consistent with Angela J. Davis, who's a law professor, not the Angela Davis, the academic, argues in her scholarship that the prosecutor is the most powerful person in the courtroom, full stop, period. And the exercise of their discretion with respect to charging, with respect to sentence recommendations, it's more than any other actor in the courtroom. And I think that systemic change has to and should start there. So in terms of root cause analysis of these wrongful convictions, this is what I meant by, if you know some of these root cause analysis, you go back to the prosecutor's office and say, this is a problem. When you get the next case of this sort, here are the things that you need to do. So I trained, for example, I would go to the training of new lawyers for Brooklyn, and I got that receipt from it was Disney World that I told you about. Guy had been in jail, I think 20 years. And I held it up, right? And said, do you want to be the prosecutor who missed this, who didn't look through the whole file? And as a result of that, a person spent 20 years in jail. I don't think you want to be this prosecutor. So at a minimum, these are the things you have to do. Now, there are other techniques that work for prosecutors. There's one chief prosecutor from Dallas years ago who would make each new prosecutor read these 3 cases, and you're not law students, so they would mean nothing to you. But these are some fundamental cases that have to do with the rights afforded to defendants. So you read that in law school, and then people sort of know the principle but forget about them. This prosecutor made them read them cover to cover, and it turns out that prosecutors began making better decisions as a function of going back to first principles. But there are a ton of potential reforms out there, and I think that they ought to be seriously engaged. But the thrust of your question is absolutely 100% right, that these systemic changes ought to start in prosecutors' offices. So the rules of ethics that we as lawyers live by say that prosecutors ought to be ministers of justice and not advocates. So this business about chalking up convictions and so forth, got to move away from that. Ministers of justice are supposed to be about fairness, about equity, not victories, but doing the right thing. I just reviewed a book for the Washington Post. It's called Just Pursuit by Laura Coates, who's on CNN. And I don't want to get in trouble for saying too much about the review because they haven't published it yet, but be out in the next few days. But she's her book is out now, so I can say she talked about her time as a former federal prosecutor, and spoke at length about the moral and ethical dilemmas she felt when obligations of the job or perceived obligations of the job forced her into positions that made her feel uncomfortable. We've got to get these offices where people don't feel that. That is to say that this sort of need to win and get convictions is not the prime motivating factor for that job, but to get it right, to do justice, that ought to be the motivating factor. Thank you, Rhea.
Thank you.
I found that interesting that they ended up changing and becoming better prosecutors after the rereading the base law. So our next question is from an anonymous attendee, which means I will read it out loud. And the question is, what led you to decide to defend Weinstein and Hernandez, referencing Harvey Weinstein and Aaron Hernandez?
So I'll go in order of, in sort of temporal order. So I would say Aaron Hernandez was about 2014 or so. So I'm a by disposition and by practice, I am a criminal defense attorney. So I defend those, particularly those people whom nobody else wants to defend, because I have a strong belief in our criminal legal system and the Sixth Amendment to the Constitution, that everybody has a right to trial. And cases like Aaron's in 2014, that was here in Boston, and because of the love for the football team here and so forth, people just hated Mr. Hernandez, just hated him. And I didn't think that he could get a fair shot at trial, or it was difficult for him to get a fair shot at trial. He ultimately did, because we acquitted him on the double murder counts. And, you know, in that case, it wasn't until his name came up that the police even really focused or cared about that case. And then once it did, the bias against him was just incredible here. So that was one of the cases that I took on again to protect the Sixth Amendment, to do what I could, at least to protect the Sixth Amendment. So, and the same with Mr. Weinstein. So Harvey's case, I would say, was about 2018 or 2019, 4 or 5 years after that. And some of you may have heard the expression, the camel's nose under the tent. Once the camel's nose goes under the tent, the whole thing flops off. But what I found in my practice and what I've learned from my scholarship is that particularly with these sorts of high profile cases, to the extent we allow a diminution of rights with respect to people whom we as a culture don't like, the criminal justice system doesn't give rights back. Once it's allowed to constrict those rights in the cases of the unpopular, then those rights remain constricted when you or one of your family members get arrested, and then you don't have the full panoply of rights that you should have, because we've now interpreted these rights in a very narrow way. We've narrowed the scope of these rights in order to secure convictions of people we don't like. And it should be just the opposite. That is to say, folks that we don't like, this is where we have to be sure that they are afforded all of their constitutional rights. That's how the system is tested, and that's how it ensures that black boots aren't coming to your door tonight and kicking it in. One case and I'll stop here, a case every first-year law student reads, or a student who takes the first course in criminal procedures, a case called Mapp v. Ohio. Mapp v. Ohio turned out to be the most important case in criminal procedure. That's the case that says that if police illegally seize evidence, then that evidence is excluded. So we call it the exclusionary rule. And when evidence is excluded, it disincentivizes the police from doing it again because they lose the conviction. So someone illegally goes into your pocket and pulls out what is indisputably drugs, but they've gone in illegally, then those drugs are excluded from evidence and the charge fails. So what happens? The next time, so that the conviction can stand, the police aren't going to illegally go in your pocket or illegally kick down your door, but rather they'll do it right. Wait until they have reasonable and articulable suspicion that a crime was afoot before they do a pat down frisk. And only if they know immediately that something is contraband, then they can go into a pocket. Or rather than kicking down your door, they do it the right way and have an objective third-party magistrate sign a warrant to let them come into the house. So in Mapp v. Ohio, very important case. That case was about someone accused of and indisputably possessed forms of pornography and child pornography that we would find revolting, and that we do find revolting. But it's because lawyers said, I'm going to represent you, Ms. Del Rey Mapp. I'm going to represent you and ensure that the police are doing this right. And those lawyers represented her. And because of that case, we now can sleep tonight. I can, my office is here in my basement. I can go upstairs and go to sleep at night and not worry about police kicking down my door without a warrant and so forth. So these are the reasons why I take certain of the high profile cases, even when defendants are unpopular.
Our next question is also from an anonymous attendee, and it is, what do you think about disenfranchisement for felony convictions?
Well, I think that once an individual has paid her or his debt to society, then there should be some process where that person can vote again. I don't think a felony conviction should result in lifetime disenfranchisement. I see nothing in the Constitution that calls for that. And frankly, I don't see anything in the Constitution that even permits it. And courts have disagreed with me on the latter, obviously. But it should not be that a conviction is a life sentence with respect to these collateral matters.
Thank you. Our next question is from Nacho. Nacho, would you like to ask your question?
Hi. Hello, Professor Ronald Sullivan. I had a simple question, pretty direct. What is like a daily routine for you? Like, what does a day look like for you?
Oh my goodness. You say it's a simple question, but it's a difficult question because my days vary so much. I take it you all know I'm a public intellectual, so it takes me in a lot of directions. What I will say though, what is consistent is that I wake up at 5:30 every morning and I do eat a little something and work out. So that's how I start each day. Then, a little later in the morning before things go, I try to read. So I'll read something, whatever I'm working on. By 9 o'clock, it really depends on what's happening. So if I'm teaching, I may on a teaching day, I'll be preparing for class. I'll share with you guys what's called the Fosdickian rule. It's based on Harry Fosdick, a famous New York preacher who once said, for every hour in the pulpit, you need 3 hours in the study. So an academic once told me that I should use, and all academics should use, the Fosdickian rule for lectures. So if I have a lecture for an hour, then I'm 3 hours in here in my office preparing for it, in my office on campus preparing for that lecture. If I'm in active litigation somewhere, I might be writing motions, or I could be on the telephone negotiating settlement agreements. I could be in a prison for several hours visiting a client or a prospective client. So, my days just vary greatly depending on, what happens. Any second I could get a call and it just takes me in a completely different direction because, somebody's been arrested and I need to jump into action, or God forbid, a student has been arrested. And there are many times when I'm up get a call at 2 a.m. and I, go down to the station and take care of those sorts of things. So my days vary widely, but they all start about the same.
No, that's really interesting. I recently started taking like midday naps, and I've definitely noticed that that's been helping me a lot. But great to hear. Great to hear from you.
I would love to take midday naps. I really would love to figure that out. I just don't have enough time in the day, it seems.
Thank you, Nacho, for that question. If you don't mind, Professor Sullivan, we'll go ahead with 2 more questions.
Absolutely.
The second to last one is from an anonymous attendee, and it is, what do you think about people who are hired as jury selection consultants? Does this harm our justice system's ability to function freely?
I laugh at that. It's a great question. I'm a bit old school, so I am even though compared to my faculty at the law school, they still see me as a baby, but I'm sort of old school in that I think I can do it better than the jury consultants. In other words, I like looking at people and making my own determinations and so forth. Though I am told, and there is data that suggests that jury consultants are quite effective. So I've had cases where, I've represented, billionaire clients, and they want to hire a jury consultant, and we do, and we sort of, figure out together who to pick and who not to pick. But I think, good old-fashioned lawyers can do a pretty good job of picking out a fair jury. Now, the broader question is, does it do harm to the system as a whole? Not necessarily. So on one register, no, but on another register, yes. And here's what I mean. So on the no register, it does not do harm. If a jury consultant can help you pick out a more fair jury, then that seems like a plus, net, that's a positive, right? Jurors will listen to the evidence and come back with a, fair verdict, and obviously you think your side is the right that's fair. So you may say, well, aren't you really saying a jury that'll pick out be biased towards you? So what I found is that there's no jury that's ever biased toward a criminal defendant. Even though we have the presumption of innocence, when you're sitting in that defendant chair, you're presumed guilty. So I'm always looking for jurors who will just be fair. And if a consultant can help in that respect, that seems to be a good thing. On the negative register, it's a bad thing. It does create a disequality in the criminal legal system as between people who can afford them and people who can't. They are not cheap. They are very expensive. And they do all these social media searches, and, they're trained in psychology and have some, very informed opinions about folks. So, but people can't afford it, don't get that. And then, so they get a different brand of justice. Now, I've always been of the view that we should bring the quality of justice up for people who do not have resources rather than push it down. And so, I wouldn't say get rid of them because others can't, but perhaps figure out a way consistent with the Sixth Amendment for indigent people to fund jury consultants in appropriate cases so that they get the quality of justice that others do not. But again, me personally, I've just found it effective to look people in the eye at closing and say, we picked you, ladies and gentlemen of the jury, for a reason. We picked you because you told us that you would be fair, that you would look at the evidence and judge this case on the evidence alone. We trusted you. We trusted that you would do that. You raised your right hand and took an oath that you would do just that. I trust that you're going to do that. And I trust that if you do that, you will find that the government failed to meet its burden beyond a reasonable doubt. So acquit my client, right? I mean, that sort of, I'm sort of was joking at the end, but that's sort of the way that I found effective in talking to jurors.
Thank you. Our last question is from Bryson Berry. Bryson?
Hello, can you hear me?
Yes.
I can hear you. Hi, Bryson.
Okay. Well, I would like to say it's very nice to meet you. And I knew you were a Morehouse man before I even looked it up. I knew you were a product of Morehouse College. So with that, in honor of Martin Luther King Jr. Day taking place this week, and since you are a Morehouse College alum, I was curious to know if his legacy had an impact on who you are, what you do, and do you have the same optimism he had about the future of this country?
Oh my goodness! Well. Thank you very much. They say you can always tell a Morehouse man, but
you can't tell him
yes,
much.
But you can't tell him much. but can I ask you, Bryson, what's your relationship with Morehouse College?
My mentor actually went to Morehouse College, and I visited many times. I was supposed to go there, but I chose Dartmouth instead, and I'm going to study abroad there during my junior year.
Oh, wonderful, wonderful. So yes, our most famous alum, Martin Luther King, his life and legacy had a tremendous impact on me, tremendous, and in the following ways. So, some of you have probably heard some of the speeches, and if you haven't, I would recommend his book, Where Do We Go From Here? One of his books, Where Do We Go From Here? I would show it to you. It's in a big stack here that'll fall down, I think, if I try to ply it out. So King had a pretty clear, well, let me do this in two ways. So one, there was an implicit challenge at Morehouse always. They would say that Morehouse College holds a crown over the heads of its graduates and challenges them to grow into it. That came from King's mentor, a remarkable scholar named Howard Thurman. And if another great book is Luminous Darkness by Howard Thurman. But he had a great impact on King, and King, you probably heard some of his speeches, and they would be in various forms repeated at Morehouse, and one was this thing about being the best that you can be. And King says it better and more eloquently than I could ever, but essentially he says, whatever is your lot in life, be the best that you can do. If it's your lot in life to sweep the streets like no other street sweeper ever existed. And then he goes on and say, sweep the streets like Michelangelo painted the Sistine Chapel, sweep the streets like this and that, sweep the streets like this and that, sweep the streets so well that when you die, it will be said that no person living, dead, or yet to be born could do it better. And, and that's the sort of thing they would sort of indoctrinate us with at Morehouse to strive for excellence in this sort of way, academic pursuits, sports pursuits, whatever your thing was, to do it really, really well and do it with integrity. Do it with integrity. I could be in the middle of a cellular biology class with Dr. J.K. Haynes, and he would stop the lecture, midway and talk about something that happened in the news and how, a particular politician didn't deal with a certain thing with virtue, with integrity and say, you are trying to become a Morehouse man. And if you are in that situation, then you have to deal with this, with integrity. So King, in many ways, so King became a preacher, obviously became a lawyer, but it was sort of his example of advocacy that really motivated me to do what I do and why I do so much pro bono free work for folks. It's this notion of being able to speak for people who can't speak with themselves. I have a particular skill set that I can deploy on behalf of folk who can't do it. And then for those who are actively sort of on the front lines doing various forms of protest and that sort of thing, I can get them out of jail. And, King had his lawyers and that group who were able to go and keep them from long stints in jail. And I do a little bit of that as well. So yes, it's a happy King Day to all of you that we just went past, but I think he's a extraordinary model of a form of integrity and virtue that we've lost, unfortunately. Thanks for that question.
So I believe Vlado's headphones have just died, so he no longer has a microphone on his end. But with that, I believe that is all the time we had for the event anyway. So I'd like to thank you, Professor Sullivan, for coming and spending your evening with us today. I'd like to thank the rest of the DPU team for helping us put on this event. And if you would like to read more about Professor Sullivan's work, there are a few links that have been sent in the chat for you to check out. If you'd like to check out more about the DPU, please check out our website, which is also, I believe, linked in the chat. Or if you'd like to support us with a donation, which is always optional, please email us at dartmouth.political.union@dartmouth.edu. So with that, Professor Ronald Sullivan, thank you very much.
Thank you. Really enjoyed it.